This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about a contract breach is excluded from a D&O policy and why an actual or alleged contractual liability or obligation of directors was specifically excluded and deprived the insured directors and officers of defense or indemnity. Paraco Gas Corporation is a closely held family corporation that distributes propane fuel and equipment. It appealed a June 22, 2023 judgment of the district court dismissing its breach of contract and declaratory judgment claims against Ironshore and Indemnity Company. Ironshore, an insurance company that issued Paraco the liability insurance policy at the heart of the dispute. It issued an insurance policy for directors and liability of officers and directors of a private company, the D&O policy, for Paraco. As its name suggests, the D&O policy provided insurance coverage for certain acts of Paraco's officers and directors. After a suit was brought against Joseph and Christina Armentano, who were Paraco officers, alleging that Joseph had transferred shares in violation of the terms of two Paraco Shareholder Agreements, Paraco sought coverage for defense and indemnity under the policy for the suit, the underlying action. In Paraco Gas versus Ironshore Indemnity, the United States Court of Appeals for the Second Circuit on June 17, 2024, interpreted the policy as it related to the facts. The district court dismissed Paraco's suit because an exclusion provision of the insurance policy unambiguously excluded liability coverage for the underlying action. The D&O policy provided a blanket statement of coverage following later by an exclusionary provision for certain acts. Section 3N exclusion provision reads as follows, quote, "The insurer shall not be liable to make any payment for loss in connection with any claim made against any insured, alleging, arising out of, based upon, or attributable to any actual or alleged contractual liability or obligation of the company or an insured person under any contract, agreement, employment contract, or employment agreement to pay money, wages, or any employee benefits of any kind," close quote. As an initial matter, Paraco conceded that 9 out of the 10 claims in the underlying action arose out of the alleged breaches of the two Paraco shareholder agreements. The suit in count 4 of the underlying action sought declaratory relief, stating that the Class A shareholder agreement remained in effect and governed the rights of Paraco shareholders, and that an agreement signed by Joseph purporting to terminate the Class A shareholder agreement was invalid. Count 4, in conclusion, alleged the existence of facts showing that appellants violated the terms of the Class A shareholder agreement, and the claim could not exist but for Joseph's alleged violation of the agreement's rights of first refusal and stock transfer provisions. Thus, the claim was clearly positioned within the policy exclusion. The Second Circuit concluded, therefore, that each claim in the underlying action arose from an actual or alleged contractual liability or obligation of Paraco, Joseph, or Christina under the relevant shareholder agreements, and thus any legal duty Ironshore had under the D&O policy to defend or indemnify Paraco did not exist, because the entirety of the underlying action fell within the policy's exclusion clause. In my opinion, as a contract, an insurance policy will always be read as written to provide coverage or eliminate coverage. Once the Second Circuit concluded that the contractual liability alleged in the underlying complaint was excluded, Ironshore had no duty to defend or indemnify its insureds. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you will be advised of every blog posting, usually 5 or 6 a week, and you'll have access to the more than 4,850 blog postings. If you watch these videos, you can also subscribe to the videos. They're also free. And if you do, I'd appreciate it if you click on the like button or the thumbs up button on YouTube and or on rumble.com. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in more detailed information about insurance, insurance claims, insurance law, or insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.